Here are some of my thoughts concerning this week's trial that I want to share with everyone. 1. Sometimes you need to go to trial in order to get a better outcome for your client than offered by the prosecution. Do not be afraid to go to trial, even on a difficult case. Plus, your opponent, the court staff and any spectators get to see you perform and you can develop a reputation. My former employer, Martin Regan, went to trial a lot. Even in defeat, clients were very pleased with him. They simply wanted someone who was sincerely willing to fight for them. 2. Be careful with experts. I thought our cross of the drug expert was effective, in part, because I didn't engage him head-on. Unless you have a similar background, the expert is likely going to win on their turf. That doesn't mean you can't score points and obtain concessions. You just need to be careful. 3. Pre-trial motions matter. Prior to trial we did a hearing to exclude our client's proffer session and won. Even though our client confessed at the scene, that session would have made it impossible for a responsive verdict on the drug quantities. And that matters in federal court. 4. Jury charges matter. In federal court you submit proposed jury charges and have a real charge conference. In state court, I will often propose a few specific jury charges. We won at the charge conference on the phrasing of the conspiracy count and I think it helped us with our verdict. So, be thinking of specific, special instructions for each of your cases. What are some of the unique or favorable issues? Look at case law and find a holding that is helpful and look to insert it into the pattern instructions. My experience is that state prosecutors tend to shit when any specific charge is requested. But, if granted, you have a rule you can argue to the jury on why they need to acquit.